You're at home. It's early morning. There's a knock at the door. You open it and two agents in jackets that say, ICE show you badges. Your heart stops. And in the next 30 seconds, most people say exactly 5 words that hand federal agents everything they need to build a deportation case or a criminal charge. Every day across America, people face ICE encounters without knowing that the same constitutional protections that apply to every other law enforcement interaction apply here too. But ICE agents are specifically trained to exploit one thing: the assumption that you have no rights. I've analyzed hundreds of immigration enforcement cases and studied federal circuit court rulings on ICE encounters. I've identified the exact psychological tactics agents use in the first 30 seconds and the exact phrases that stop those tactics cold. This is educational content only and not legal advice. For your specific situation, always consult a qualified immigration attorney. Let's break down how ICE gets you to incriminate yourself and exactly how to stop it. Mistake 1: answering, "Where are you from?" The mistake. The agent is at your door or has approached you on the street. Before anything else, before showing a warrant, before explaining why they're there, they ask one simple question. Where are you from? Most people answer immediately. I'm from Mexico. I'm from Guatemala. I was born in El Salvador. That answer just gave federal agents the foundation of a civil immigration case in under 5 seconds. The scenario. You're walking to your car in the morning. An agent in plain clothes approaches and says, "Hey, quick question. Where are you from originally?" You think it's casual. You say, "I'm from Honduras, but I've lived here for 12 years. The agent nods and says, "Do you have documentation?" The encounter has begun, and you started it by establishing your foreign origin on the record. Why people do it? Sounds like small talk. It doesn't feel like a legal question. People answer because refusing feels rude, suspicious, or confrontational. Nobody thinks a geography question is the opening move of a federal investigation, but it is. Legal reality. The Fifth Amendment to the United States Constitution protects every person on U.S. soil, citizen, permanent resident, visa holder, or undocumented, from being compelled to be a witness against themselves. This was affirmed as applying to non-citizens in Zadvitas versus Davis, 533 U.S., a 678, 2001, where the Supreme Court explicitly stated that constitutional protections extend to all persons within U.S. borders, not just citizens. Answering questions about your birthplace, your country of origin, or your immigration history is not required. It is voluntary. And voluntary answers to federal agents are fully admissible in immigration court and in federal criminal proceedings. Evidence problem. ICE agents are required to document field encounters. When you answer, "Where are you from?" that answer goes into a written report, an I-213 form. The record of deportable or inadmissible alien. This form is generated by the agent, not by a court. It becomes a primary document in removal proceedings. The I-213 has been recognized by federal courts, including the Ninth Circuit, in Patel versus INS as admissible evidence of alienage. Your casual answer to a casual question becomes a federal document used to remove you. Officer psychology. ICE agents are trained in what the agency's own field operations manual describes as consensual encounters. Interactions where the person is not technically detained but is being questioned. In a consensual encounter, you are free to leave and free to stay silent. Agents know that most people don't know this. They use conversational, low-stakes openers. Where are you from? How long have you lived here? What's your name? To build a factual record before the person realizes they're being investigated. The correct move. Here's phrase 1. Exercise it calmly and clearly. I am exercising my right to remain silent. That's it. You are not required to state your name to ICE in most circumstances during a consensual encounter on the street. And you are never required to answer questions about your birthplace or immigration status. Say it once. If they keep asking, repeat it. I am exercising my right to remain silent. Why it works. This explicitly invokes Fifth Amendment protection. Under Salinas versus Texas, 570 U.S. 178, 2013, the Supreme Court ruled that silence alone is not enough. You must affirmatively invoke the privilege. Saying these words on the record, which may be documented or recorded, establishes that you are asserting a constitutional right, not evading a question. It cannot be used as evidence of guilt in a civil immigration proceeding, and it forces agents to pursue other legal methods if they want information. Bottom line, never answer "where are you from?" or any question about your national origin, immigration status, or how you entered the country. The correct answer is always, "I am exercising my right to remain silent." Mistake 2. Opening the door. The mistake. The knock comes. You open the door all the way. The agent steps partially into the threshold and begins asking questions while standing in your doorway. Most people back up, allowing the agent to enter, or they answer questions while standing in the open door, not realizing that what they say inside or from inside their home can be used against them, and that they had the right to simply not open the door at all. The scenario. Early morning, a knock. You open the door. 2 agents identify themselves as ICE. They say, "We just need to ask you a few questions." You step back out of politeness. They step forward. Now they're inside, looking around and asking you about the other people who live in the residence. Why people do it. Opening the door when someone knocks is instinct. Authority figures in jackets feel like they must be complied with. People don't know that without a judicial warrant, ICE has no legal right to enter your home. Legal reality. The Fourth Amendment protects the home as the most sacred space in constitutional law. The Supreme Court held in Payton v. New York, 445 U.S. 573, 1980, that absent exigent circumstances, law enforcement cannot enter a home without a judicial warrant. This applies to ICE, an administrative warrant, Form 200, Warrant for Arrest of Alien, or Form 205, is issued by an immigration officer, not a judge, and does not give ICE the authority to enter your home. Only a judicial warrant signed by a federal judge or magistrate, issued under the authority of a federal court, authorizes entry into a residence. The Ninth Circuit reaffirmed this specifically in the immigration context in United States v. Sotelo, and multiple federal district courts have consistently held that an I-200 does not satisfy the Fourth Amendment warrant requirement for home entry. Evidence problem. If you open the door and agents enter, even if they were not invited and even if you didn't explicitly say, "Come in," anything they observe inside becomes potentially admissible under the plain view doctrine established in Horton v. California, 496 U.S. 128, 1990. Other individuals in the home may be seen, identified, and detained. Documents visible on tables may be noted. Your decision to open the door wide and step back can be interpreted as implied consent to entry. Officer psychology. Agents conducting early morning operations are trained to use the surprise of a knock, before people are fully awake, before they've had time to think, to conduct what are legally consensual encounters at the doorway, or to obtain implied consent to enter. Knocking before someone is alert is tactically designed to get compliance before awareness. The correct move. Here's phrase 2. You can speak through a closed door or through a window without opening it. I do not consent to your entry. Do you have a judicial warrant? If they say yes, ask them to slide it under the door or hold it to the window. Read it carefully. Verify it is signed by a federal judge or magistrate, not an immigration officer. Verify it has your correct name and address. If it is a judicial warrant for your address, you must comply. If it is an administrative warrant, or if they cannot produce a warrant, I do not consent to your entry. You do not have to open the door. You can say this through the closed door. You are not obstructing justice by exercising your Fourth Amendment right. Why it works. It establishes on the record that any entry was non-consensual, which is critical if you later need to challenge the legality of the encounter in immigration court or federal court. If agents enter without consent and without a judicial warrant, your attorney has grounds to move to suppress any evidence obtained during that entry under the exclusionary rule established in Mapp v. Ohio, 367 U.S. 643, 1961, which applies in the federal criminal context, and courts have applied similar suppression arguments in immigration proceedings. Bottom line, do not open the door for ICE without asking for a judicial warrant. The correct response is always, I do not consent to your entry. Do you have a judicial warrant? Mistake 3. Signing documents. The mistake. You've been stopped, detained, or taken into custody. An agent places a form in front of you and says, "Just sign here. It's standard paperwork." Or, "This just says we talk to you." Or, "If you sign this, we can process you faster." Most people sign. That signature may have just accepted voluntary departure, waived your right to a hearing before an immigration judge, or admitted facts used to establish your removability. The scenario. You are being processed at a detention facility. The agent slides over a Form I-826, Notice to Alien of Rights and Disposition, or a Form 1274A, or a stipulated order of removal. You don't read it fully. You sign. You have now potentially waived your right to appear before an immigration judge and contest your removal. Why people do it? People in detention are scared, exhausted, and often dealing with a language barrier. Agents may present signing as the fastest way out. People assume the paperwork is neutral or administrative. They don't realize these forms can carry legal consequences equivalent to a court ruling. Legal reality. Under the Immigration and Nationality Act, specifically 8 U.S.C. Section 1229A, every person in removal proceedings has the statutory right to a hearing before an immigration judge. This right can be waived. And one of the most common ways it is waived is through signing forms during detention without understanding their legal effect. The Board of Immigration Appeals has held in multiple cases that a signed stipulated removal order constitutes a valid waiver of the right to a hearing if it was knowingly and voluntarily signed. The word voluntarily is doing enormous legal work there. You also have the right under 8 CFR, Section 287.3 to be advised of your right to counsel before questioning. Evidence problem. A signed document carries extraordinary weight in immigration proceedings. Unlike a verbal statement, which can be disputed, a signature creates a formal legal record. Courts give significant deference to signed forms, placing the burden on the individual to prove the signature was coerced or the waiver was not knowing. A very high bar. Officer psychology. Processing agents are not your advocates. Presenting forms quickly with minimal explanation in stressful and often chaotic detention environments takes advantage of the pressure of the moment. The framing, this just speeds things up, is designed to make signing feel like the cooperative, self-interested choice. The correct move. Here's phrase 3. I do not want to sign anything until I have spoken with an attorney. You have the right to contact an attorney before signing any document in an immigration enforcement context. Under 8 CFR, Section 287.3c, detained individuals must be advised of their right to counsel. Say this clearly every time a form is presented. I do not want to sign anything until I have spoken with an attorney. If you cannot afford a private immigration attorney, nonprofit organizations and immigration legal services provide representation. The National Immigration Legal Services Center maintains a directory of free and low-cost providers by state. Why it works. This invokes your right to counsel before a critical legal decision. It does not obstruct the process. You will still be processed. But it protects you from waiving rights you didn't know you had. If agents continue to pressure you to sign after you have clearly invoked your right to counsel, that pressure itself becomes a potential due process issue your attorney can raise. Bottom line, never sign anything in an ICE encounter without an attorney. The correct answer to every form is, I do not want to sign anything until I have spoken with an attorney. Mistake 4. Trying to explain your situation. The mistake. You are detained or being questioned. You want to explain. You have a pending application, a U.S. citizen spouse, children who were born here, a visa that expired only recently. You think if you just explain the situation, the agents will understand and let you go. So you talk. You provide dates. You describe entries. You mention family members. You explain your work history. Every word of that explanation is being documented and can be used in your removal proceedings. The scenario. An agent asks, "How long have you been in the country?" You say, 13 years. But I have a pending case. My wife is a citizen. We filed the I-13 2 years ago. The agent writes it all down. You have just provided a timeline of unlawful presence, identified a family member who may now be contacted, and described the status of a pending application, all without being asked for any of it specifically. Why people do it? It is human to want to be understood. People believe context will help. They believe showing their ties to the community will generate compassion. These instincts are understandable. But ICE field agents are not adjudicators. They are not authorized to grant relief. They cannot approve your application or stop a removal based on your explanation. The only person who can help you with your explanation is an immigration judge or an attorney. Legal reality. Anything you say to an ICE agent can be used in removal proceedings under the federal rules of evidence as an admission. No statements made during custodial interrogation without Miranda warnings are subject to suppression in criminal proceedings under Miranda v. Arizona, 384 U.S. 436, 1966. However, the Supreme Court held in INS v. Lopez Mendoza, 468 U.S. 1032, 1984, that the Fourth Amendment's exclusionary rule does not apply in civil deportation hearings in most circumstances. This means the protections that might get a statement thrown out in criminal court may not protect you in immigration court. The standard is lower. The stakes are just as high. Evidence problem? Every detail you volunteer, dates, locations, names of family members, descriptions of your entry, your employment, creates a factual record that immigration prosecutors can use to establish removability, to locate other individuals, or to contradict later testimony if any detail differs even slightly. Officer psychology. Agents who have a detained individual know that anxiety drives disclosure. The more frightened someone is, the more they talk. Some agents ask open-ended questions. Tell me about yourself. Walk me through what happened. Precisely because open-ended questions generate far more information than specific questions. Specific questions limit the answer. Open questions invite people to fill silence with details they were never asked for, the correct move. Here's phrase 4. Use it for every question about your history, your situation, your family, your entry, your employment. Everything. I'm exercising my right to remain silent. I want to speak with an attorney. 2 sentences. Both matter. The first invokes your Fifth Amendment privilege explicitly, satisfying the Salinas requirement. The second invokes your right to counsel, creating a clear record that you requested legal representation. I am exercising my right to remain silent. I want to speak with an attorney. Do not explain. Do not give context. Do not tell them about your pending case or your U.S. citizen children. Your attorney is the correct person to present that information in the correct legal form in the correct legal way. Why it works. These 2 sentences, spoken clearly and repeated calmly every time a question is asked, protect you from creating the evidentiary record that removal cases are built on. They do not stop the detention. They do not guarantee release. But they prevent you from making your own case worse, which is the single most common way people accelerate their own removal. Bottom line, say nothing about your history, status, entry, or family to ICE agents. The only correct answer to every question is, I am exercising my right to remain silent. I want to speak with an attorney. Here are your 4 phrases. Write these down. Keep them somewhere accessible. Practice them until they come out automatically, because in an ICE encounter, your heart will be pounding and you will not have time to think. Phrase 1. I am exercising my right to remain silent. Use this when asked anything about your origin, your status, or your identity. Phrase 2. I do not consent to your entry. Do you have a judicial warrant? Use this at your door before opening it. Phrase 3. I do not want to sign anything until I have spoken with an attorney. Use this every time a form is presented. Phrase 4. I am exercising my right to remain silent. I want to speak with an attorney. Use this for every question about your history, your situation, or your family. These rights exist because the Constitution applies to every person on U.S. soil. They were not created for any specific group. They were established by the Supreme Court, the federal circuits, and the text of the Constitution itself to protect everyone in this country from government overreach regardless of status. This is educational content only and not legal advice. For your specific situation, consult a qualified immigration attorney. If you or someone you know may face an immigration enforcement encounter, contact a nonprofit immigration legal services provider in your area before an encounter happens, not after. If this helped you understand your constitutional rights, share it with everyone you know. These 4 phrases could be the difference between a protected encounter and one that goes permanently on the record. The law does not protect people who panic and talk. It protects people who know exactly what to say and exactly when to stop.